So within the realm of probate, there are several different pieces of the puzzle, several different entities that are created that end up in probate court. One of them is a guardianship. And what is a guardianship versus a conservatorship versus a standard probate versus a trust? Excited to have here with us today Jackie Cara Law, founding partner. Jackie, thank you for joining us today.
Thanks, Bill. It's great to be here.
So short version for the layperson or for a real estate agent, what's a guardianship versus a standard probate or a conservatorship?
So a guardianship is something that happens when somebody is either disabled and needs continuing support, which is a guardianship that I frequently handle with disabled children. So as children turn 18 and their parents need to continue supporting them, we need to move for legal guardianship because at 18 we lose all of those powers as parents. So we want to continue those powers with children who have developmental delays, some children on the autism spectrum, traumatic brain injuries, things like that, where they need the parents to really continue with that legal authority.
Got it.
The other place where I see guardianships frequently is in the senior population, primarily around people who either haven't planned, so there's nothing in place and they become incapacitated, or they have planned, but their plans aren't working, which usually means there's been some sort of breach of fiduciary duty, a power of attorney not doing the right thing. And we see guardianships come up there.
Ooh, it's funny. I feel the same way on that one that you said, a little pointed. I said it to another attorney, and they pushed back on that a little bit. So let's go to the first one first, though. So guardianships are often a case where, and I don't know, you practice in San Diego?
New York.
New York, okay. So the terminology might be different in California in that when somebody is an adult, even if they're disabled and their child is a guardianship on their children, and then they become of age, I believe it becomes a conservatorship. But I don't give legal advice here. But that case where you have adults who need to be provided for because while they're of adult age, they're not of adult ability. So what are some of the types of protections or tools you can use to help those children? Because obviously on one hand you have parents, on the other hand, there's not too many people going to have the same interests as parents, and parents get older, it gets tougher to be involved. So what kind of tools do you have, or what kind of options are there to help children who are now adult but maybe aren't capable of taking their own lives in control?
So you make an excellent point. In California, they are conservatorships, and I would basically say they're the same thing. For ease of explanation, they're the same thing. So there are all of those famous guardianships. The first one that always comes to mind is Britney Spears, and that's a little bit of an in the middle guardianship that I'll talk about. But the most frequent time that guardianships come up in my practice is when parents have a child that at age 18 cannot care for their own needs. They can't make medical decisions, financial decisions. They need somebody to whatever degree to continue interfacing with their doctors, their financial planners, applying for benefits and things of that nature. So there's two mechanisms. Actually, there are three mechanisms now in New York. There's a guardianship proceeding through the surrogates court, which is an Article 19 proceeding, which is very much reliant on medical data. So in order to achieve success in that type of proceeding, the parents need to have medical professionals who can provide us with affidavit proving that the child is incapacitated. The other one, which is where Britney Spears would fall, but with a disabled child aging out, is an Article 81 guardianship, which is in Supreme Court. And that's a little bit more, say, of the cases where it might not be obvious from the medical information that the child needs a guardian. And so we have a little bit more of an involved court proceeding that's a little bit more tailored to the needs of the child in question.
And you use the Britney Spears case just because it's in the public eye so much. When you say that it's not as clear medically, meaning one can debate about her behavior, right? There is a case you made that she's acting normal for an entertainer to get attention. That's what entertainers do. And there's a flip side, which is this is evidence that she's perhaps risking self-harm and we need to take control. And it's debatable as that process of evidence gets debated in court.
Exactly. And here in New York, an Article 81 guardianship doesn't necessarily need the medical testimony.
Right.
It's all based on showing the court that somebody cannot care for their activities of daily living is how the court looks at it. So they're mismanaging finances, they're putting themselves at risk, they're making poor medical decisions. And in the Britney Spears type of case, I'm actually working on a case now with an adult child who has schizophrenia. And he's unable to make medical decisions for himself. He's not speaking to, he's not getting the medical care he needs. So there, we have to prove to the court that it's more than just him making choices we prefer him not to make, but it's actually some sort of a deficit where he needs intervention to keep him safe.
And I think oftentimes it's easy to look at a case and make a conclusion one side or the other. Again, use the Britney Spears case, not because I'm a big fan, but I will say when I went to court every day pre-COVID, every month or two there was a Britney, riot or Britney protest. So you can't help but notice it when you're there. But I do think that on one hand, it's heartbreaking to see somebody messing up their life and somebody with great talent not getting the benefits of their hard work, and that's evident in that case. But the flip side, it should be hard to take away their rights for self-determination. Not saying impossible, but there should be a high bar. That bar should be, in the law, that bar should be verified by a court or whatever the process is. But still, it should be a high bar for one to lose their rights to determine where they work, how they work, what they do with their money, those kinds of things. And so talk a little bit about the balance. How do you, obviously people come to you, they want you to do what they want you to do. They want you to get control of their child who's maybe out of control, or they want you to fight that. The child comes to you, I don't want to be in a conservatorship or guardianship and fight out of it. So, not talking about how do you make a decision on taking a case, but how do you see kind of the social issue of balancing between protecting people and taking away their rights by being too aggressive?
So you make an excellent point. This is a very good question. Guardianship's a serious matter, right? And I don't know that most people really think it through that much, but guardianship's very serious, right? You're really taking away the person's civil rights, right? So unlike a power of attorney where the person who drafts the power of attorney and the agent they appoint can work side by side, like that person can still go to the bank, but the agent can go to the bank. In a guardianship, whatever rights are given to the guardian, the person loses. So they can't also go to the bank, they can't do those things, right? So it's a very serious infringement on rights.
The ultimate almost, besides death, but the ultimate.
And it should be. So in New York, the standard is pretty high, and the proof that we move forward with is pretty high. And of course, like everything else in the law, right? It comes down to the judge you're talking to. It comes down to the representation the person receives. But in New York, so the way a guardianship works in Supreme Court, where we have a question about a person's capacity, there are safeguards in place, right? Aside from the notice requirements where the person has to receive personally a very extensive packet of information, they're also entitled to counsel, and the court appoints somebody to take on a role called a court evaluator. And a court evaluator, they're the eyes and ears of the court, right? They're a neutral party who is supposed to go out and investigate all of the claims and meet with the person you're alleging to be incapacitated and determine whether that person needs counsel. So you can have a guardianship like that one we're talking about, where there is both a court evaluator appointed to talk to the judge about their findings and counsel appointed for the alleged incapacitated person to represent their interests in the case. So, we want to sort of pack a lot of protection around the person we're saying is incapacitated in those cases.
And yet that protection isn't free. It gets very expensive and very cumbersome, right? When the judge has to review things, it's not that judges are of their own nature inefficient, but the nature of somebody observing so many different people, so many different cases becomes inefficient, right? And so by nature, their inefficiency becomes legal expenses, more meetings, more visits, more court reports, more depositions, more this, more that. And so is the establishment of a, let me back up a little bit. So children, by their nature, are under the care of their parents. But if they don't have parents, or the parents lose their right, here in California, we have guardianships that are established for those children, right? Mom and dad pass, unfortunately, and maybe aunt and uncle become the de facto parents. They're the guardians of those children.
Yes.
When those children become adults, does that automatically cease, or is there a process to continue based on their capacity? Meaning, on one hand, you can have children who have capacity or normal otherwise, and other kids who maybe have developmental issues where they're going to be 18 and you're going to have a problem. What are you going to do about it at that point?
So in New York, at least those guardianships you're talking about where the parents have died, tragically died and left children behind, there is a guardianship proceeding, but it's in family court. So it's a different type of proceeding. And that proceeding, that just like a parent, that proceeding, that authority terminates when they turn 18. So if there were in there also a developmental delay of some incapacitating nature on that child, those custodial parents, we'll call them, or guardian parents, would have to proceed through one of these other methods to gain, adult guardianship, we'll call it.
So have to redo the process in essence, even if they know they're headed there. That's where you go. Okay, so all that is in some ways similar. I think California, most states. Let's talk about avoiding it, because we're on Estate Planning Weekly, and obviously the goal is if you have children, I would say whether you own a house or have children, you should have an estate plan in place.
Of course.
Nobody expects to die or have both parents, God forbid, pass away, but you should have those in place. And people say, well, it doesn't matter. We have all our grandparents. In my case, my daughter, who now has 2 kids, is married, lives near us. And, they have 4 grandparents alive. Well, but who makes those decisions?
Right.
And everybody gets along until they don't. Once they don't, you have a problem, and those problems can end up in court. So let's talk about first the nature of parents for children who have any special needs. They're just children, but parents should provide for them in case they're not around. Can a good estate plan avoid the need to have that custodial relationship in court?
Yes and no. So there's always some process, right? Where children are concerned, there's always going to be some process. But the best point that you just brought up is fighting. So I always tell people when I talk about estate planning, I want to empower you to make decisions so they're not being made by somebody else, and perhaps somebody you don't want making them. So in your example, if those parents died in a common accident, both sets of grandparents might end up fighting over the guardianship of the children. And it might not be either set of parents they want acting as guardian. It might have been a brother or a sister or somebody else in the family. And now you sort of have a free-for-all at what should be a simple appointment proceeding, where the court has some oversight of this guardianship. But now you've complicated it. Now you have litigation. Now you have people fighting and all kinds of things happening that don't need to happen. Right. You can go a tremendous way to protecting your children and who's going to take care of them by naming a guardian, by having an estate plan. And if you're a young couple, the most important part of that plan might be naming guardians for your children and setting up a trust to care for your children, for their future.
And so what's the process like? If you set that plan ahead of time, you name, well, let me back up a little bit. Sometimes the person best able to be the guardian or custodial parents aren't the best ones to decide who should be, right? Like in our case, I don't know if it's true or not, but I could see a case where perhaps my daughter might say, well, I don't, my parents and my in-laws' parents, my son-in-law's parents might not be of, we're older. So for us to take over the children would be physically demanding. And of course, you write the plan today with 5 or 10 years in mind, and we're getting older, and it might be harder. So they might choose to have one of the siblings to be in charge, but the sibling might be the right one to raise the children, might not be the one to make the decisions on how the children are raised. So sometimes there's 2 different parts there the parties have to kind of agree to, and ahead of time that can be discussed and the solutions can be made. But once you get to court, that's where both sides have attorneys. It seems to me like they both have guns, or they're both going to use them. If you bring a gun to a gunfight, you're probably going to use it, I would think.
Yes. So I see a lot of these problems arise, frankly, where there's money.
Oh, imagine that.
Almost universally, every guardianship I've worked on where I start to see a guardianship contest, I ask where the money is. So unfortunately, that definitely plays a role.
Yeah.
But if you're pre-planning, like I encourage people to do, like you're encouraging people to do, you're naming the person you would select as guardian, you're naming a backup for that person or backups for that person. And you're also setting up a trust, and the trustee of the money the person in charge of the money, can be a different person than the guardian that's taking care of the children. And this is a much more frequent issue when there is money, right?
Imagine that.
If you have a large estate you're leaving behind and you want to have your sister act as guardian for your children and she doesn't have any financial acumen, or you want to make sure you're balancing the interest, you might appoint somebody else as the trustee of that trust.
Right. Or advise her to get a professional fiduciary to give her advice on one particular. So those are things you can plan ahead. Right. Once you're in the midst of it, you can't. And so I think all these are complicated questions that, to a large part. That said, one of the common misconceptions, I know the answer I'm going to ask you anyhow because you're the guest, most common misperceptions I get from customers is they'll say to me, well, if I have an estate plan, that will avoid litigation. And I'm thinking, no. No. It might improve your chances of success dramatically. It might reduce the percentage dramatically. But my experience is anytime there's a lot of money, somebody's going to sue somebody over something.
Yes. I started my career as a litigator. So I always wear my litigation hat when I'm planning to try to see the pitfalls in the plan where the door could be open. But there's always a possibility for litigation. Just because somebody may not succeed does not mean they can't sue. So very often there's a lawsuit brought, even one that won't succeed on the merits, because people are fighting and they're angry and they don't like the outcome.
Well, and often filing the lawsuit is a negotiating tactic.
Yes.
To say that even if at the end of the day I'm going to lose, you're going to spend a lot of time and money to get there, and it'll drag things out for a while, or we can come to an agreement, and it moves their perception of where they'll end up closer towards them. They might get everything they want, but it's a process. So the reality is probably not. But in estate planning, you can also, I think, there's some tools you can put in a plan to discourage frivolous litigation or make the bar for litigation higher, right? There's different provisions I've seen where if you challenge the trust, you get less of inheritance or no inheritance. So talk a little bit about those tools as a way to help eliminate the fight and how that plays into guardianships as well.
Well, I don't know how much it plays into a guardianship, but it definitely plays into litigation over estate plan, over wills and trusts and stuff at the end of somebody's life, because I always talk to clients about making sure you're leaving a carrot behind. I have a lot of clients that come to me and they say, I want to disinherit this child. And that's the most common scenario where this comes up. And I say, let's talk about that, because it might not be wise to disinherit a child. That might not be the right strategy. Sometimes the right strategy is providing enough money to dissuade them from suing by also including a no contest clause in the document. So you want to give them something. If you're giving them zero, they have nothing to lose. If you're giving them a sum of money, that's enough of a carrot, right? They might respect that clause in the documents. That's a no contest clause. So that's one of the strategies that we use in planning.
So I'd like to talk a little bit about kind of the business of law, if you're okay with that.
Sure.
And I ask this question almost every turn, though. Any question I ask, you don't have to answer. Obviously, I'm not paying you for this advice. But as a business person, you've been in the business a while, and you have a reputation. You're referred to me, established. Yet I find that still, like most business people, you start to spend some time doing business development. Can you describe a little bit like what percentage of your calendar in your mind do you feel like you spend developing business, doing great podcasts like this, versus just the actual billable hours serving customers and such?
I probably spend about 30 or 40% of my time on business development. And that's not necessarily direct communications with sources or things like that. It might be on improving the information I'm providing to my clients. I'm always trying to build in more content that I send to my clients so they understand what we're working on. It might involve, I do a lot of networking. I belong to a lot of networking groups where I meet other people, where I can sort of help their business and they can help my clients. So I do a lot of that type of work. And I do a fair amount of pro bono work and a fair amount of public service in my bar association. So that's sort
Nice.
of what my business development looks like. And I would say at this point, it's probably 30 or 40% of my time.
And I think that's the most common answer I get, just
Yeah.
FYI. Whether the top producing attorney in Southern California as a managing partner of a big firm or they're smaller, older, established, it seems like that seems to be kind of the magic number for anybody that's not declining in volume. So, okay, and then obviously there's certain things you do for attorney referrals, i.e., pro bono work, I imagine, and some of the networking, and then other work you're networking outside that. So, talk a little bit about like what percentage of your business comes from attorneys versus what percentage might come from other professionals like real estate agents, financial professionals, accountants, or consumers that know you through your family and friends.
So probably about 50%, 40 or 50% of my new business is old business. It's either a referral from a prior client, or it's a client coming back, or it's a friend of a family member, or, things like that. So I would say that's a pretty big piece of my business is satisfied people coming back for help. The next biggest part of my business is other attorneys. But surprisingly or not, primarily divorce attorneys. A lot of
Oh,
divorce attorneys are pretty savvy about the fact that when you're going through a divorce, you probably want to update your documents so it's not your soon-to-be ex making medical decisions for you.
right,
That's a pretty common request, and
right.
the need to do new estate planning after a divorce because it changes things.
Makes sense. Virtually every divorce attorney should have a good estate planning attorney on the other end. That makes a lot of sense. I never thought about that one before. Um, I can see where succession and inheritance makes sense for any attorney, right? I have attorneys who get referrals from litigators because they win a $2 million judgment. Now they got to collect, and the estate has maybe a house, and then the guy dies. Well, now as a creditor in California, they can probate the case and collect that way, and we get that done. In your case, working with divorce attorneys, it seems to be natural. So talk a little bit about where do you network with attorneys, and where do you network? Well, let me start with that one. Where when you say networking, bar association events or specific content events related to elder law, or where do you network with attorneys?
So a few places. I'm very active in the Bar Association. I chair a committee there, and I know a lot of people at the Bar Association level, at the state level and the local level. I also do a lot of networking at business networking organizations. I belong to this group called USA 500, which is a sponsored professionals group. So it's all attorneys, CPAs, financial advisors, and people adjacent to those professions. And we help each other quite a bit because if I'm an estate planning attorney, but I have a client with a real estate problem, right? I need a trusted advisor for that real estate issue. And I belong to a few other networking groups like that. I also like to do teaching and things like that to advise people of what their rights are. I find a lot of people don't know what their options are, or they think they know what their options are. So I've spoken to some seniors groups, and I've been to some community centers to speak to people in the community about how to plan for your estate.
And then on the flip side, let's talk about, because a number of people following my platform are disproportionate share real estate agents. So I'm sure that along the way, you have clients, whether it be through divorce, through the natural life, inheriting properties and such that need a real estate agent. Name one or two effective ways that you've seen realtors come to you locally to do business with you? Meaning, the companies that sell marketing advice, cold calling, which I hate, cold calling the attorney, which I hate, cold calling the petitioners, which I hate. And I've always really pushed about education and using networking to get there. Talk a little bit about what would you advise if you had a nephew or a niece who are starting in real estate and wanted to work in this field and learn more. Where would you recommend them to network or get involved with attorneys like you?
So I think a great opportunity is a networking organization, right? I know a group like BNI has a lot of real estate agents in it, and then there's a lot of attorneys and other professionals in that group, so you can sort of build a coalition around your business. I think education is great. I know real estate agents who are very proficient at understanding their clients' needs around a purchase or a sale. And they're very proficient at adding value for their clients by saying, now's a great time to maybe think about a trust since you're buying this house. Maybe now's a great time to update your planning documents. And those are great referrals for me. But I also have people like that I can make referrals to when my clients are buying or selling or transacting real estate business. And I think that's a great value add for your clients.
Yeah, I think it's really important, the knowledge and being able to help, and then for you having the Rolodex, and then I'm sure the other pieces of the Rolodex that you could benefit from that an experienced agent might be able to bring, right? The house comes sometimes with junk or with collectibles.
Yes.
Either it's very valuable stuff that needs help with, or it's very bad, dirty, scary stuff. I deal with both, right? I have various hazmat companies that have specialties, and I have also high-end collectibles and such, and from valuables to please get the dead body smell out of the house. I have had.
Oh yes, how do we do that? How do we do that?
Yeah. Okay. Well, look, Jackie, I really appreciate the time that you spent with us today talking about estate planning, and in particular guardianships and the related issues of taking care of family members who become maybe medically disabled or born with different challenges that we want to take care of along the way. If somebody wanted more information about you, I guess we would point them to your website, JackieCaraLaw.com. That's the best place to meet you?
Yes, it is.
And you have a start planning button. Talk about the process. When somebody comes to your website, if they're interested, what does that look like when they hit the start planning button?
So if they hit the start planning button, they'll be linked to a little website information form. And actually, I get an email or a text message from my automated system so I can reach back out to them.
Nice.
I have some internal forms that I like to send people just so I get a feel for what they're looking for. So that'll trigger them getting this, very brief information form, who they are, what they're looking for, what their concerns are, and a link to my calendar so we can schedule an initial talk.
Fantastic.
Yeah, and I have, an initial 30-minute talk with people who come through my website, see what their planning needs are, if we're the right fit. And then we go through a planning process. We have some planning tools, and we have a more in-depth conversation and some education. And then we get to work on their documents.
Fantastic. Well, look, Jackie, I sure appreciate the chance to meet with you today for our audience, and thank you for the information you shared, and we'll continue to work together going forward.
Thank you. It was great being here.
And for the rest of you, this is Estate Planning Weekly. We get together every week with estate planning, usually attorneys, sometimes vendors, talk about how to better serve our customers by helping them avoid litigation or minimize litigation. I'm Bill Gross, at Bill Gross Probate, and social media. You can continue the conversation on our Facebook group, the Estate Planning Podcast. If you have questions, looking for referrals in other states for vendors or for attorneys, love to help you there. As always, if I can help, reach out. At Bill Gross Probate, call, text. If you have other attorneys or vendors you'd like to have on this podcast, feel free to make suggestions. And as always, make today your best day ever. Thanks so much.